Good morning, everyone. This is Madeline Howard with Western Center on Law and Poverty, and today we're going to be talking about confronting discrimination with California's new fair housing regulations. So I want to first just put this in the larger context. I have not been able to attend the rest of the conference because of the eviction cliff that is currently happening. And we're in a pandemic and we wanted to be together in the same room to talk about these issues, and instead we're on Zoom confronting all these silly technical issues all the time and not being able to be together. And this conversation that we're going to have today about housing discrimination feels particularly important in this moment. The most vulnerable people in our country are being hit on all fronts at the same time, with the coronavirus, with now impending massive numbers of evictions, with loss of jobs, with immigrants being targeted in all kinds of ways by our horrendous Trump administration. So this all feels so important right now, and also particularly challenging when we can't be in the same spaces together. And as was with everything, evictions, all of the things that are happening right now are hitting some communities harder. They're hurting people of color more, and everything is intersectional, right? And so this all feels particularly important right now. And everyone who does this work already knows this, but where you live impacts everything about your life. So housing discrimination is really exacerbating all of these effects. And the things that we're going to talk about today with these new fair housing regulations impact everything about housing. The bigger decisions, like where housing is sited, whether a community even allows low-income housing to be built at all, and also individual decisions. Can this person who has disabilities be allowed to actually use and enjoy their housing fully? What about this person who has a criminal record? Is the landlord going to actually let them rent? So we're going to talk about all of that today. And before we go farther, I want to introduce our amazing panel. So everyone here today did a lot of work on these regulations that we're going to discuss. It was a long public process, and we submitted multiple comment letters through the process. So I want to invite my fellow panelists to introduce themselves, and starting with Ugochi and Marie-Claire. You can go ahead because I can see you.
Good morning, everybody. Ugochi Annabera Nicholson. I'm the directing attorney for our Affordable Housing and Homelessness Prevention Unit at the Public Law Center in Santa Ana, California. Nice to meet everybody.
Hi, everyone. I'm not sure if you can see me, but you can at least hear my voice. My name is Marie-Claire Tran-Leong. I am the director of the Legal Impact Network at the Shriver Center on Poverty Law. I'm really excited to be here with you all today to talk about these important regulations.
Thank you, Marie-Claire.
And I'm Scott Chang. I'm the Director of Litigation for the Housing Rights Center, which is a nonprofit for housing organization located in Los Angeles.
Thank you, everyone. I really appreciate Scott and Marie-Claire and Ugochi joining us today. I know that they are, like I am, caught up in everything that is happening, and thank you so much for being here. Okay, so before we kind of go into some of the specific topics of the regulations, I want to give just an overview to sort of orient us. This is what we're talking about today. So the Fair Employment and Housing Act is our state anti-discrimination law. And the equivalent on the federal level is the Fair Housing Act, and that was passed as part of the Civil Rights Act. And in California, we have FEHA, as it's known, and we have the Department of Fair Employment and Housing, is the state agency that is charged with enforcing these anti-discrimination laws. And the new regulations that we're going to be focusing on today, they explain parts of FEHA that relate to housing. They don't cover all of the housing sections yet. It's sort of a work in progress. But these regulations, they don't change the law, they just explain what it means. They were written by the Fair Employment and Housing Council, which is sort of the policymaking body for the DFEH, specifically by Dara Scher and Tim Iglesias, who worked very hard to make these regulations happen. They're the first ones that ever have been put into place for the housing discrimination sections. And right now, actually, the public process is ongoing for additional parts of the regulations. So stay tuned for that. And actually, before we kind of talk about why this matters to you, I think you've already chosen to be here, so you know it matters. But can we pull up the poll to hear a little bit about the people in our audience today? Thank you. So we're just asking everyone to give us an idea how much you know about fair housing, and then sort of what kind of work you're doing in this area. Okay, thank you so much, everyone, for participating here. It looks like we have lots of folks who have some knowledge of fair housing, and then plenty of newer folks and people from all different areas of practice. We've got developers and local government, state government organizers, service providers. Thank you so much, everybody, for that. Just helps us kind of know who's in the room, in the virtual room. Okay. So why do we care about this? You're here, so you already know this, but FEHA matters in so many different areas of housing law. So these rules and regulations, they apply in landlord-tenant relationships, they apply in the way that homeless shelters are operated and where they're sited. They apply in city zoning actions and also in individual development decisions, in interactions with real estate, financial services, insurance. They also apply to all kinds of interactions with people with disabilities who are seeking accommodation. And then they also just broadly apply whenever there's a decision that has a discriminatory effect. Marie-Claire is going to explain this a little bit more, but even when someone is not intending to discriminate, these laws still apply. So there's a lot here. Okay, so this is what we're going to cover today. So introducing the Fair Housing Act, the Fair Employment Housing Act, which is what I'm already doing. And then specifically, we're going to focus on some of the categories and the regulations. Scott is going to tell us about land use discrimination. I'm briefly going to talk about financial and real estate practices. Ugochi is going to discuss reasonable accommodations, and Marie-Claire is going to talk about criminal records. And then at the end, we're going to take a minute to talk a little bit more about who is liable for these types of decisions and how we enforce these protections. Okay, so FEHA is structured just like the Fair Housing Act in terms of these protected classes. So it says that you cannot treat someone worse or treat them differently or deny them housing or do any of these things based on their membership in a protected class. And this here is a lot of words because there are many, many protected classes. And I'm not going to read these through, but you can look at them. I just want to highlight a couple of protected classes here because they were changed effective this year or broadened. So race obviously is a protected class, but this year that was expanded with the Crown Act. So Holly Mitchell, who is a champion of many amazing things, led this effort. And what this does is it expands the definition of race discrimination to also protect people based on the way that they wear their hair, the texture of hair. So it's saying that you can't discriminate specifically against an African-American person who chooses to wear their hair natural. And there's just ridiculous stories of people being treated badly because of the way that they wear their hair. So that is now specifically covered in the law. We also expanded source of income discrimination. And this is something that housing advocates have been working for such a long time. Source of income has been in the law for a long time, but it did not cover someone's use of a Section 8 mobile housing voucher, and now it does. So previously you would often see, and unfortunately you still do see this some of the time, but in a housing listing, no Section 8. Don't apply here if you have Section 8. So that is no longer allowed. And in addition, military and veterans are additionally protected where the law now says that you cannot be discriminated against for using a veterans voucher. So some more protections there. Okay, so a few basics about the regulations. So these regulations came into effect on January 1st of 2020, which now seems like ancient history because it was before the shelter in place and the pandemic. But even though they only went into effect in January, they interpret previously existing law, so they don't change the law. And if you want to cite to them, we have an example here. They are in the California Code of Regulations. You can get them on Lexis and Westlaw. And you can also get a copy of the regulations on the DFEH website, and we have the citation here. Okay, so now we're going to talk about some specific practices that are touched in the regulations, and I'm going to turn it over to Scott to talk with you about land use discrimination.
Great, thanks so much for having me. I'm excited to be here to discuss one of the tools that could be used to achieve greater housing equity and assist in the production of more affordable housing, the recently adopted land use and zoning regulations from the Department of Fair Employment and Housing. And I'm going to start by talking a few minutes about the history of land use and zoning to provide some context for fair housing and land use and zoning and the regulations. So this is just a brief history of land use and zoning and fair housing. From 1880 to about 1968, when the Fair Housing Act was passed, there were racially restrictive covenants. These are deed restrictions that prohibit the sale of or rental of homes to particular racial groups. From 1880 to 1917, there was explicitly racial zoning. These are land use and zoning restrictions that specifically exclude racial groups. Next slide. And then from 1870 to the present is implicitly racial zoning. So these are land use and zoning restrictions that are neutral on their face, but have a discriminatory effect on protected classes. So restrictive covenants, it will come as no surprise to you that all these land use practices have their origins in systemic racism. So restrictive covenants were endorsed by the federal government. The Federal Housing Administration recommended that restrictive covenants be used in the homes that they insured and sometimes required it. They were very common in California. For example, the Westlake subdivision, which is an extremely large subdivision in Daly City, south of San Francisco. All the homes there, starting in the 1940s, had restrictive covenants. And this here is an advertisement for the Eagle Rock neighborhood of Los Angeles. And you can't actually read what it says, but it says, restrictions create a community of beautiful homes. The residents of Eagle Rock are all white or Caucasian race. So restrictive covenants were eventually found unlawful by the Supreme Court in 1948, but they continue to be found in deeds across the country. And they're one of the specific discriminatory land use practices that are barred under the regulations. So then we come to racially explicit zoning. And this is the situation where cities create separate zoning areas for whites and non-whites. In California, in 1880, San Francisco had an ordinance that prohibited Chinese Americans from certain areas of the city. Eventually, that particular ordinance was struck down by a federal court, and then in 1917, the practice was ruled unlawful by the Supreme Court across the country. And that brings us to the present day, which are implicitly racially exclusionary zoning, which was from 1890 to the present. And these are situations where municipalities find other ways to segregate using land use and zoning laws. And one example, again, comes from San Francisco. In 1890, a lot of the Chinese Americans lived in lodging homes there, and they were very densely housed. And San Francisco adopted an ordinance that required that each person have 500 cubic feet of space around them. And it was a violation of the ordinance was penalized by criminal penalties, including jail time. So hundreds of Chinese Americans were jailed during this time period. Then in 1908, the Los Angeles City Council passed the first municipal zoning ordinance in the United States, which separated portions of Los Angeles into residential and industrial districts. And that sort of just continued to today. Today, municipal zoning codes often include regulations related to building density and height, property lot size, placement of buildings on lots, and the uses of land use in particular areas of the jurisdiction, all of which can have the effect of unfairly excluding people in protected classes from certain neighborhoods. So with that historical background, the first fair housing laws were passed both federally and in California, in part to deal with discriminatory land use practices. And discriminatory land use practices have always been at the heart of fair housing laws. The Supreme Court, recently recognized that land use and zoning cases are what they call heartland cases, are cases that deal with the purpose of the Fair Housing Act and are critical to the desegregation of our neighborhoods. So now turning to the regulations, I think the regulations are just generally very exceptional. And I think the land use and zoning regulations stand out in particular. And there's a couple of reasons for that. One, it provides a comprehensive set of guidelines that define which types of land use practices might be discriminatory. And then two, it describes the ways in which a land use practice can be discriminatory. There's really nothing comparable on the federal level. And so these land use and zoning regulations are a huge achievement and really advance fair housing law. And they're a tool that could be used when developers or community groups are seeing resistance to affordable housing in their communities, because they sort of really clearly lay out like what types of things violate, what types of land use practices violate fair housing laws or the Fair Employment and Housing Act. So in terms of what's covered under the land use regulations, it includes both public practices or governmental practices and private land use practices. It applies to existing zoning or existing housing, and also housing that hasn't been built but provides opportunities, housing opportunities for people. Next slide. So in terms of how a land use and zoning could be proven to be discriminatory, there's a couple of different ways, and the regulations sort of put all the different ways together. So one is intentional discrimination. So that would be showing that a protected class such as race was one of the reasons why a particular land use decision was made. Or as Madeline referred to earlier, the land use and zoning restriction can have a discriminatory effect upon a particular protected class. And sort of the classic situation to illustrate this is where an affordable housing project is blocked by a municipality or other government. And in that case, we know that people in the protected classes are more likely to live in affordable housing because based on their incomes as compared to white. So when a affordable housing project is blocked or impeded, then it precludes them from that housing opportunity. A second way is perpetuating segregated living patterns. This is a method or proof that goes back to the sort of foundation of the Fair Housing Act, which was designed not only to be an anti-discrimination act to prohibit individual acts of discrimination, but also to desegregate our neighborhoods. So you can prove that a land use practice is discriminatory by showing that the action that was taken perpetuates segregation. So in the example, an affordable housing project, if it was in a white area or predominantly white area and the affordable housing was going to be affordable to people, Latinos, or Blacks, then you would be able to show that it perpetuates segregated living patterns. And then the final way is acquiescence to bias or prejudice or stereotypes of the public. And this happens even though the governmental actors might not have made any discriminatory comments themselves. So one example of this is where opponents to affordable housing use like coded words like the people that are going to live there have large families, they're going to bring more traffic or crime into the neighborhood. Under the regulations, those type of statements might be indication of discrimination. So there are two things that you would need to prove to show a discriminatory land use practice, and one would be if it falls within the examples that are provided under the regulations for unlawful land use practices. So there's a number of them listed, and I encourage you to take a look if you're interested, but they range from very broad prohibitions like making housing opportunities unavailable or denying housing to unintended occupants. So the example of affordable housing, if it's blocked, to more discrete and sophisticated types of practices, such as the provision of inadequate services such as water, sewage, or garbage collection. And an example of that is before I joined the Housing Rights Center, I worked for a firm in DC, and one of our cases involved a neighborhood in Ohio where African Americans were excluded from the municipal water service for over 50 years, even though their white neighbors who lived down the street sometimes had water service. So under the DFEH regulations, that could be a violation of the Fair Employment and Housing Act. Next slide. So a couple other examples. Ugochi is going to talk about the concept of reasonable accommodation. Maybe at the end, if there's questions, we can talk about how that applies in the land use and zoning context. Another type of practice that could be unlawful under the Fair Employment and Housing Act is actions that result in the location of toxic, polluting, or hazardous land uses in a manner that adversely impacts housing opportunities. I mean, there have been studies that have shown that race has a primary role in where these types of toxic, polluting, or hazardous plants are located. And under the Fair Employment and Housing Act, that could be a violation if you could also show that it was discrimination. Next slide. Okay, so now we're gonna do a poll, and I'll go ahead and read this, and which tries to put together the concepts that I've just talked about. So a developer owned land that it wanted to develop for higher density affordable housing, which was permissible under the applicable zoning. Before the developer could break ground, the city rezoned the parcel of land to preclude the construction of higher density developments. The city is predominantly white with a decreasing Black population. A significantly higher percentage of Blacks in the city qualify and need affordable housing. And there was opposition to the development based on concerns about parking and crime. So a situation where a developer wanted to develop affordable housing, but the development was blocked by the city, who changed the zoning for that particular parcel. So question is this a fair employment and housing violation? 1, yes, probably. 2, maybe, or 3, no. So if you could vote, that would be great.
Do we have the poll coming up? I'm not seeing it on my end.
Yeah, I'm not seeing it either. Well,
I'm sorry, the polling function is not working correctly, so my apologies.
Well, maybe we could just use the chat to answer Scott's question. Is this a FEHA violation or not?
Okay, so it seems like most folks are saying yes, probably, and I think that's the right answer. So this practice of a city changing the zoning to preclude affordable housing is one of the discriminatory land use practices which could be unlawful under FEHA. And then to prove that it's discrimination, first we know that blocking this affordable housing project likely had a discriminatory effect on Blacks because they qualify and need affordable housing disproportionately compared to whites. There could be evidence of intent here, not because the government officials said anything directly, but because members of the public opposed the development based on concerns about parking and crime. And those could be like code words for concerns about race. And then finally, there could be a violation under perpetuation of segregation because the city is predominantly white with a decreasing Black population, and the affordable housing that would have been developed would presumably have residents who were African American, and the effect would be to desegregate the neighborhood. So now there are a couple of discriminatory practices that are specifically referred to in FEHA, and those include discriminatory nuisance ordinances, overbroad criminal record policies, and then anti-immigration policies. I'm just going to talk quickly about discriminatory nuisance ordinances. Next slide. So these are practices that require the eviction or other adverse actions against tenants or guests based on calls to law enforcement or emergency, visits by law enforcement or emergency, and there are broad definitions of what's unlawful or criminal conduct under the nuisance ordinance portion of FEHA. And the reason why these types of policies are included in the regulations is because when you think about the people who might call law enforcement, they're largely probably people in protected classes. So that would include domestic violence survivors who might call the police because their former partner has approached them. It includes people with mental disabilities who have, who often are subject to calls to the police based on their conduct, either because another resident is reporting them or management is reporting them. And then also we know that there are disproportionate policing of Blacks and Latinos in our country. So next slide. So we have another poll for you, which if you could answer in the chat box. So the city has an ordinance which requires owners of rental property to evict tenants who cause a nuisance. Nuisance is defined to include the frequent response by police department to real property or the adjacent area. So the question is this a FEHA violation? The answer is 1, yes, probably, 2, maybe, or 3, no. So it looks like most people are answering yes, probably, or 2, maybe. I would say that the answer is probably yes, probably, although maybe could also be the answer. I think it probably depends on whether or not you could show that the people that are affected by this nuisance ordinance are members of the protected class. But certainly the practice of evicting tenants who cause a nuisance, the city requiring owners to evict tenants who cause a nuisance would be one of the practices that could be unlawful under the Fair Employment and Housing Act. And then the question would, can you show that it was discrimination? And in that case, you would look to see if in that particular area, a nuisance ordinance such as this would have a discriminatory effect upon members of the protected class. Next slide. And then the final land use and zoning area that I'm going to talk about is immigration policies. So the land use and zoning section of the regulations prohibit policies that require adverse actions based on immigration status or legal residency. It provides some exemptions as required by federal law or court order, but they're fairly narrow. And we have one last example, which we'll ask you about. This is an example of the immigration provisions of the land use and zoning regulations. Wapples Incorporated acquires a rental property and institutes a policy requiring all tenants to provide proof of lawful immigration status. Tenants who do not comply receive a 3-day notice to cure or quit, basically an eviction notice. Is there a FEHA violation here? And the choices are yes, A, yes, B, no, undocumented tenants are not protected by FEHA, or C, no, as long as the landlord applies the policy equally to tenants of all races. So it looks like people are answering, seem to be answering a yes, which is the correct answer. Immigration is particularly is protected under the Fair Employment and Housing Act, and this is a land use or zoning restriction that applies to private housing and could be a violation of FEHA. So thanks very much. I'll turn it back over to Madeline.
Thank you so much, Scott. Okay, thank you everyone for your patience with the polls not working. So we're gonna answer questions in the chat. And then if you have questions for us, if you could please use the Q&A box, and we will get to those at the end. I'm gonna very briefly talk about a couple of areas that are covered by the regulations. Financial assistance practices and real estate practices. And these two sections are quite similar to each other, so I'm talking about them together. Financial assistance practices, as you heard from Scott, we have, and I think people are aware of this, we have a very long history of intentionally segregating people and intentionally stripping Black communities and other communities of color of assets. And I have here just a redlining map from the area where I live in Alameda County. And if you overlay like environmental hazards maps, if you overlay heat maps, like we saw recently in the New York Times, you can see that these historically, these neighborhoods that were intentionally stripped of assets and harmed in the past are now still being subject to more harms from environmental hazards and actually hotter and all kinds of things. So this is all of these historical patterns are still with us today. And one of the big ways that that happens is through discriminatory practices of banks and other financial institutions. And this is specifically covered in the regulations. And the regulations in section 12100 prohibit a lot of different types of conduct, including some things that are really obvious, like applying less favorable terms to someone, say you're charging higher interest or more fees to someone's loan based on their membership in a protected class, like based on race. But then also things that are a little bit harder to see, like not giving information to certain groups of people. Like, I'm just not gonna welcome you in the door. I'm not gonna give you all the forms that you need. I'm gonna make it harder for you to access financial assistance. Applying a formula that results in certain people getting less favorable loans. There's been a lot of litigation on this, mostly under the Fair Housing Act, but I think with these regulations, there'll be more enforcement under FEHA as well. Banks do all kinds of terrible things, including in Wells Fargo litigation, the bank was literally looking at people's last names. And if someone had a Latinx last name, or it appeared to them from the name that was the racial category that the person belonged to, they would just get a worse loan. We're going to charge you more money. We're going to make it easier for us to foreclose. So just really egregious stuff. So the regulations cover that, but they also cover categories where there's a discriminatory impact. So even if the financial institution is not trying to discriminate, if the practices that they have, like looking at a certain zip code and giving worse rates to that zip code, if that has a discriminatory effect, it would still be prohibited by the regulations. And thank you, David, for putting the article that I mentioned in the chat. And a lot of the things that I just mentioned would also potentially be covered by land use regulations. There's some potential for looking at different parts of the regulations for the same conduct. Okay. Oops. So real estate practices. Again, the regulation calls out specific types of conduct, some of which are pretty obvious, and covers both intentional and disparate impact discrimination. So I'll just give a couple of examples of what this would look like for a real estate practice. One is something like steering, where someone who's engaged in real estate, a realtor, an agent, is taking some families to certain neighborhoods that are maybe more desirable. Maybe that's like, oh, you're a white family. I'm going to take you to this rich place where there's really great schools and good jobs. And this African-American family, I'm going to take you over to the other side of town that's less desirable. So something like that is blatantly discriminatory and would violate FEHA. But then again, that same category where it's a little bit more subtle. of just sort of not inviting people in order to facilitate their access to housing. And so I wanted to give one specific example. I'm talking a little bit quickly because we're a little behind on our time. But one specific example that would violate multiple parts of FEHA would be this housing regulation, this housing advertisement. And you can look quickly at this. I've highlighted it to make it a little bit easier for you, but see if you can spot the discriminatory statement in this advertisement. So also just flagging that discriminatory statements is the topic of new regulations that have just been put out by the Fair Employment and Housing Council, and they are going to be going through the public process. So I don't see anyone answering in the chat, but the example here is just that this advertisement says that no Section 8 will be accepted for this housing. Yeah, and I see people answering, thank you. So this is now prohibited both by source of income discrimination, and this would also be a discriminatory real estate practice, listing housing with this statement that they are not going to take Section 8. Okay, I'm going to turn it over to Marie Claire now, who's going to talk with us about criminal records.
Thanks, Madeline. The regulations cover criminal history information, which is really significant because it's really the first of its kind where a state has regulated the use of criminal history information. We've seen a lot of ordinances. We've seen the federal government through HUD talk about it, but this is really the first time where we've seen a state really use its regulatory power to look at criminal history records. And so before we kind of delve into the regulations, I thought it would first be useful to talk about what types of criminal history information it's talking about. Somebody in the chat, I think, had earlier mentioned formerly incarcerated individuals. So, the kinds of records that you see that are being regulated are the use of arrest records, conviction records, and also other interactions with the criminal legal system that don't fall within those categories. So, for example, diversion programs or deferral of judgments where the outcome is a non-conviction, and basically records of interactions that a person has with the criminal legal system. So one thing I just want to note is that under FEHA FEHA doesn't necessarily say that housing providers cannot use criminal history information. There's no broad prohibition against that in the same way that there is against protected classes such as race or disability. What it does say, what the regulations essentially say is that housing providers may use criminal history information, but really only under limited instances. So we'll move to the next slide. So I think the easiest way to think about this is to look at first what are sort of the more cut and dry rules of what the specifically prohibited practices are. So housing providers cannot use the following information. One is, if we can move back one to the specifically prohibited practices. Thank you. The first is arrests that have not resulted in conviction. The idea being that an arrest is really just a indication that a person has been accused of something, but not that the person has actually done it. You can't use diversions or deferral of judgments. Again, these usually result in non-convictions and are the court's way of allowing a person to move past or not have all the collateral consequences of a conviction record. Records that have been sealed, dismissed, vacated, expunged, validated, or pardoned. So essentially this group is a group of records where a person probably has a conviction and they've gone through some sort of judicial process to have that record either stricken from public view or have some sort of indication that this record doesn't have the same force as it did before the process. Sometimes a person might have a certificate of rehabilitation that's issued from a court, and that is not supposed to be used against a person. And then juvenile records. I think the idea being that we're really, looking at what happens in the criminal legal system, and the juvenile system is supposed to be separate from that. And then one area that I did not, one very big area that I forgot to put in this slide, and that I caught this morning, is that the federal regulations say that you cannot prohibit, or excuse me, that you cannot use blanket bans against people, broad categories of people with records. And so what does this mean? They took the language of blanket bans from a guidance that HUD released in 2016. And essentially what that means is that a housing provider cannot categorically say that they will not allow anybody with a criminal record to live in this housing, or they cannot say anybody with a felony record. Basically, these are categorical exclusions against people, broad exclusions against people with records, that don't allow for any sort of information beyond what's in the four corners of the criminal background check. This is really significant because I think in some places that this is still common practice, that's definitely outside of California. And so, so what the regulations really say is that this has to be a much more narrowly tailored process, and that housing providers cannot just ban broad categories of people from housing. So if we move to the next slide, section, this section prohibits housing providers from using criminal history if it constitutes intentional discrimination or it has a discriminatory effect. And so those are, we've kind of, I think Scott and Madeline have both mentioned this. The regulations in general look at these two different types of discrimination. And so we'll walk through what this looks like in both of those categories. So for intentional discrimination, in the next slide, what this really looks like is where a housing provider uses criminal history information as a proxy for a protected class, such as race or national origin. And in those cases, those are kind of I think what people typically think about in terms of housing discrimination. That this is clearly violates FEHA. So I put an example here of a report that came out in 2017 from the Equal Rights Center, which is which does fair housing work out in Washington, D.C. And in that report, they sent testers out to apply for rental housing. And the testers, they sent out white testers, they sent out black testers, and the testers had identical criminal history records. And what they found through the course of this report was that even though the two groups had identical records, the way that they were treated in terms of the screening policy, in terms of the application process, was quite different. So whereas the white testers were often treated with much more, there was a willingness there to kind of forgive what had happened, to set it aside as a youthful indiscretion or to explain it away. For the black testers, there was a much more stringent application of the record, and saying that you shouldn't apply, you shouldn't bother applying, we don't let anyone with this type of record onto our property. And so where there are those instances where it's clear that maybe the same policy is being used differently based on a person's status within a protected class, that falls within the intentional discrimination bucket and would be clearly a violation of FEHA. We go to the next slide. Another area where I think it's pretty straightforward to think about what a violation is discriminatory statements. And so how this comes up in the criminal records context is that housing providers cannot publish notices or advertisements that conflict with these regulations. So earlier, Madeline brought up this Craigslist ad, and it said no Section 8. But similarly, problematic would be a statement there where it said no felonies or no criminal records, because as I mentioned, blanket bans where you deny anybody with a criminal record or anyone with a felony is a violation of FEHA. They What is lawful, however, is advertising a lawful screening policy. So again, this kind of goes back to the original point I made, which is that housing providers can screen, and but it's a matter of figuring out to what extent they can do so under FEHA. And advertising a lawful screening policy is not unlawful. So if we move to the next slide, we've talked a little bit about discriminatory effect, and I'm just going to go over kind of in a broad brush again in the criminal records context. In essence, under discriminatory effect, what you're looking at is racially or a neutral policy. Usually we talk about racially neutral because we're talking about race as a protected class, but it's a neutral policy that could have a discriminatory impact on protected classes. And under FEHA, there's 3 steps that you have to look at. The first is discriminatory effect. The second is looking at whether there's a legally sufficient justification. And then the last is, well, okay, well, I will go through this in turn. But essentially, a practice has a discriminatory effect if it actually or predictably results in disparate impact on a group of individuals, or it creates, increases, reinforces, or perpetuates segregated housing patterns based on membership in a protected class. So if we go to the next slide, we have what we have here is a slide that looks at the racial and ethnic disparities in prisons and jails in California. And if you were just to look at this, you can see that there are significant disparities, particularly for the Black population and then the Latinx population. And so this is just one snapshot and one, there are many different points of the criminal legal system, from arrest to release, and throughout a lot of those points, there are often racial and ethnic disparities. And so if a housing provider is using criminal history records, they really need to look at the discriminatory effect that it will have on these populations. So if you go to the next slide, for step 2, what the housing provider must show is that the challenge practice has a legally sufficient justification. So what does that mean? I mean, it means that the practice is necessary to achieve a substantial, legitimate, non-discriminatory business interest. The practice carries out that interest, and that there are no feasible alternative practice that would be achieved with that would have achieved that interest with less discriminatory effect. So this is, a lot of legal theory here, but so I think what in these contexts we often try to say is, what does it mean? What does it mean for housing provider on the ground or person looking for housing? What are the practical effects of this? So if we go to the next slide, one of the things that's really that we really note is that when you're talking about legal justification, it needs to be supported by evidence and not just something that's hypothetical or speculative. And where this typically comes into play is around public safety. Sometimes there's a tendency to say, well, we screen because it makes our housing safer. But there is a lot to interrogate in that statement, and looking at, I think, whether this is actually supported. And we've seen, for example, there's a study out of Minnesota where there are affordable housing providers that have actually looked back at their criminal record screening policy and found that admitting people who had records didn't make their property any less safe. So really have to kind of look at evidence and figure out, are we advancing this policy because it's based on speculation, or is there evidence behind it? If we move to the next slide, housing providers really must only use criminal history information regarding directly related convictions. So what is a directly related conviction? It's a conviction that has a direct and specific negative bearing on the identified interest. So for example, I have represented clients before where they may have had a shoplifting violation, and that was used against them. And we've gone to the housing provider and said, you know, this person has been a good tenant in other situations, and the shoplifting in and of itself didn't necessarily have a negative bearing on either safety or ability to be a good tenant. And so really you have to look for that that connection between the conviction and the interest before you look at it. So moving to the next slide, again, in determining whether a criminal conviction is directly related, the practice should include consideration of the nature and severity of the crime. Again, you know, is this a very serious crime, or is it something that's pretty minor? And also the amount of time that has passed. So the idea being that as time has gone on, the likelihood of engaging in similar activity is decreased. And then the last consideration is if there is any feasible alternative is there any feasible alternative? So when you're looking at a policy, some of the factors to consider are you giving the opportunity for mitigating evidence? Is there an opportunity for a person, again, to show that they are more than the four corners of the criminal background check? Or are you really only relying on that piece of paper? There's also, you also have to consider, are you allowing people to show that records are inaccurate? Because there's a lot of problems with accuracy and with records. There's the regulations also list as a factor, is there delayed consideration of criminal history? Are you kind of looking at all the other factors first, such as ability to pay, and other related factors before you kind of dive into the criminal history? And then another factor is do you give a copy of the criminal history to the prospective tenant, so that, again, they can know what's being used against them, they can correct inaccuracies, and they can prepare to show you the mitigating evidence. So why don't we, so we'll move on to the next slide. And just talk a little bit about mitigating evidence. For mitigating evidence, what that means, again, is are you looking at the whole picture? So some of the examples that they have is, was this person a minor or a young adult at the time of conduct? What is the amount of time that has passed since the date of conviction? And has there been good tenant history before and after the conviction? Has there been evidence of successful rehabilitation efforts? So have they undergone substance abuse treatment or some sort of program that would help them? Another that I just wanted to note is status as survivor of domestic violence. We have often represented individuals who have their criminal record arose from the fact that they were a survivor of domestic violence, and being able to explain the broader picture of that and why that the record shouldn't be used against them. And we also have represented people who have status because of their disability, and being able to, again, give a fuller picture of what happened, and really looking at other facts and circumstances. So that's an overview of the criminal records. I think probably for the interest in time, I'm going to skip over the hypos for now and let you go to talk about the reasonable accommodations.
Thank you, Marie Claire. Ugochi, you want to talk about reasonable accommodations?
Yes. Let's see if I can get myself situated here. There we go. Good morning, everybody. My name is Ugochi Nicholson. It's a pleasure to speak with you guys virtually by Zoom. So I want to loop back to what Madeline said earlier today in terms of the need for affordable housing opportunities for low-income people at all levels, and most particularly for those who are people with disabilities. So the next slide. Today we will not cover reasonable modifications, which are changes to the physical structure of a building, such as installing a ramp or widening doorways. Different rules apply. And so, as Madeline mentioned earlier, at the Fair Employment Housing Council, there are regulations coming forth, and one of those regulations are reasonable modifications, so stay tuned. Next slide. So what is a reasonable accommodation? A reasonable accommodation is a change to an exception to, or exception to a rule, policy, or practice that's necessary to provide the person who has a disability equal access to use the housing opportunity. It must be necessary, so there must be a direct and logical connection, what's legally called a nexus, between the accommodation being asked for and the disability. There's no need for the tenant to use magic words such as "I need a reasonable accommodation." We've had examples of tenants saying, "I need more time to pay my rent because I receive subsidized SSI." So they don't use the word reasonable accommodation, but that is an example of a reasonable accommodation. Next slide. It is permissible for a housing provider to use formal procedures. That's a 2 California Code of Regulations 12176, but the housing provider cannot require it. And it does not replace the duty of the provider to engage in the interactive process. On that form, if the housing provider decides to use a formal procedure, they can't ask for information that's not going to help them to the decision-making process of if they're going to grant the reasonable accommodation. And those forms and procedures are themselves subject to the reasonable accommodation process. So if a tenant needs more time to complete it or needs assistance in completing the form that they're being asked to complete to submit for their reasonable accommodation, then the housing provider needs to give that as well. Next slide. So we'll talk a little bit about the interactive process. Next slide. Oh, sorry, backwards, sorry about that. The interactive process, so if there's a situation where the landlord is not going to grant the reasonable accommodation outright, they must engage in the interactive process, which is a process of negotiation between the landlord and the housing provider, the landlord and the tenant, to determine if there is an accommodation that is possible for the tenant to avail themselves of if the landlord is not going to grant the requested accommodation outright. It must be come to in good faith, so the landlord must come to the process in good faith. Next slide. So oftentimes the interactive process does break down. What is the tenant who is in need of an accommodation to do? So the tenant can continue to ask for the reasonable accommodation. The landlord must be able to provide some type of an accommodation. And if the landlord does not provide the accommodation, it may serve as the basis of a fair housing complaint or a violation. Next slide. Reasonable accommodation and necessity. The tenant must be able to provide documentation showing that it's necessary for them to have the accommodation. So that means, sorry, I lost my train of thought there. So that means that there must be a nexus between the requested accommodation and the person's disability. So if there is no nexus between the person's disability and the requested accommodation, it is possible that the landlord may be able to deny the accommodation, but then engage in the interactive process to determine whether or not there is another accommodation that could be granted. Next slide. So a person with a disability can establish the necessity of an accommodation by establishing a need for the accommodation. And so that may be the use of a doctor's note, not explaining what the disability is, but what the symptoms are related to the person's disability that support the need for the accommodation. If the disability is readily apparent, such as someone using a walker or a wheelchair, then the landlord or housing provider is not allowed to ask for additional information to establish the necessity. Next slide. So that takes us to our first hypothetical. I'll read it. Samara is a person who uses a power wheelchair, and she requests a reasonable accommodation for her landlord to move the garbage and recycling bins to the other side of the garbage bins so that she does not have to go to up a step to drop off her garbage and recycling. What other additional information can be requested from Samara to process her request? So if people can identify their answers in the chat. Okay, seeing some good answers. And yes, that is correct. D, neither Samara's request is sufficient. And it's sufficient because she has a disability that's readily apparent. She uses a power wheelchair, so she is not needing to provide any additional information to the landlord. And that's at 2 CCR 12178. And so we'll go to the next hypothetical. Okay, you are the property manager at an apartment complex. Joanne, a tenant, comes to your office with her 8-year-old son, Alex. Joanne says Alex has a developmental disability and noises severely disturb him. Joanne asks to move to a top floor apartment so there won't be any noise from steps and dropped items. You have not noticed any unusual behavior from Alex in the past. What additional information can you request from Joanne to process her request? A letter from her doctor with Alex's diagnosis. B, a signed release from Joanne to speak with Alex's doctor. So you may ask the doctor about Alex's disability. C, verification from reliable third party that Alex has a disability and the request to move upstairs is related to the disability. D, all of the above. E, none of the above. Joanne's request is sufficient. So looking at the chat, I got some mixes, but mostly seeing the right answer. And the answer is C, verification from a reliable third party that Alex has a disability and the request to move upstairs is related to the disability. So A is incorrect because the housing provider is not entitled to know the diagnosis. That's actually prohibited under state and federal law. B is incorrect because that breaches the duty of confidentiality between Joanne and her doctor. And it also violates the request to get more information about Alex's diagnosis. And D is incorrect because A and B are wrong. And E is incorrect because C is the correct answer. You may, as a housing provider, obtain a reliable third-party verification that indicates that Alex is a person with a disability and there's a nexus between the requested accommodation to move to the top level apartment and the disability. Next slide. And so that section is at 2 California Code of Regulations 1278. And the third-party verification is important allowed because Alex's disability is not readily apparent or known. And so it's being based upon behavior that has not been observed from where he has lived. Next slide. We talked about a denial of a reasonable accommodation. And so that is allowed when the requester does not have a disability, when there is no disabling need for the accommodation, such as no nexus between the disabling condition and the requested accommodation. It will fundamentally alter the services or operations of the provider. It will be unduly financial and administratively burdensome. On undue financial and administratively burdensome, it has to be substantial. So it cannot be something de minimis. It has to be substantial, and it has to be both. We have had cases where a landlord will say, I can't afford it, but it's not going to be burdensome for them to provide the accommodations. So the housing provider needs to provide both in order to be able to justify a denial. And the other one is direct threat to the health and safety of others, or substantial physical damage to the property of others. And the housing provider must show, if they are going to deny it on a direct threat, that the risk cannot be mitigated by another reasonable accommodation. And the housing provider must be able to show that in the case of a direct threat, that they tried to provide mitigation, because we've had cases where there have been no mitigation and it's just denied as a direct threat. So there's a whole analysis that actually has to come forth. Next slide. So we have a lot of questions that come forth about assistance animals, and that's defined at 2 CCR 12005 subdivision D. And service animals and support animals are covered under 2 CCR 12185. With regards to service animals, it's permitted to ask the individual, are they people with disabilities, and what is the task that the animal has been trained to perform, but the housing provider cannot ask the tenant to have their service animal perform a demonstration. Similarly, with support animals, there are a lot of online certifications out there, and that aren't really helpful because they don't help provide information to the provider about what exactly the support animal provides the person with the disability. So in that realm, the requester is permitted to ask for additional information. But however, they cannot ask for pet fees or additional rent. They may have to cover the cost of the tenant may have to cover the cost of damage caused by an animal. The next one is pretty big because we've seen this in a couple of cases that we've had of recent. There cannot be a breed or size or weight restriction. I had a case involving a pit bull where the dog was a pit bull mix, and the requester was asking my client that they could not agree to the restriction or the accommodation because the dog was too big. And so had the dog been about 7 pounds lighter, the provider said that they would have granted my client to move into the unit with the dog. And so we explained to them that this violates the law as a breed and size restriction. And so we were able to get that issue accommodated for our tenant. And the request can be denied if an animal poses a direct threat. Next slide. So this is the third hypothetical. I'll read it. Machiko requests an exception to her property's no pet policy as a reasonable accommodation so that her friend Yoshi, who has a non-apparent disability, can visit with his emotional support animal, should the landlord grant the request. So I'll let people answer in the chat. Okay. Okay, seeing that mostly, let me see, getting some answers of yes, some answers of no. And the answer is, I got it, they should, but they probably don't have to. And so the answer is actually yes, that they needed to provide the accommodation. She can ask it on behalf of her friend because it's in terms of access to the property and being able to fully enjoy the property as compared to someone who does not have a disability. And so, and note, if Yoshi had a service animal instead of the support animal, the animal would be permitted pursuant to 2 CCR 12185B without the need to request an accommodation. I do want to make one mention before we move on back to Madeline, and that is in the area of evictions. This is a hot topic, especially around this pandemic. We recently made an accommodation using these regulations in court for a tenant who was faced with a loss of a stay of eviction, and the judge granted additional time for her to remain in the property because she was a person with a disability. So we made that accommodation notwithstanding the fact that she was in the midst of an eviction post-judgment. So the tenant can request a reasonable accommodation at any time, including for the first time in an eviction and even through the eviction process. So I do want to make that mention before I move on. Thank you.
Thank you so much, Ugochi. Yeah, I think this is particularly, I'm glad you kind of ended with talking about evictions because that is so relevant to this current moment, especially when we're seeing the courts reopen for evictions, and for some people it is for everyone really, it's hazardous to your health to go to court. But for some people particularly so, if they have vulnerabilities or someone who is elderly in their home. So thinking about reasonable accommodations in the context of evictions is really important. And before I talk about who is liable for discriminatory conduct, I also just want to kind of bring everything that we've talked about together. So I think you've probably gotten the idea that these regulations cover a tremendous number of topics over just covering so many different aspects of housing. We started out hearing from Scott about land use and how these siting decisions, like both where to put housing, but then also where to put other things, like things that emit toxic fumes and hazardous waste. And so all of these things are touched by these fair housing regulations, both individual decisions as well as the decisions that cities and counties are making about how they sort of map out the community. And so there is a lot here, and hopefully what we've discussed today will encourage folks to take a look at the regulations. They are written in a way that's much more accessible than a statute and not so much legalese. There are a lot of examples, especially in the land use section and also in the reasonable accommodation section, that really kind of explain this is what the law means. So really encourage people to take a look at those. And there was a link on the slides for how you can get to a copy of just all the regulations together. Okay. So this is Donald Trump Sr., this lovely face here on the slide, in case you're wondering who's liable for discriminatory conduct. So I want to just talk about this for a moment to give an idea of how broad this is in terms of liability. So I'll use just sort of the landlord-tenant context. I think it's helpful for explaining. Oftentimes when we as tenant advocates are assisting someone who is experiencing a discriminatory housing practice, oftentimes it's like the maintenance person or the property manager who seems to be directly engaging in discrimination. So we wanted to flag that the employer is often liable for the conduct of the employees under these regulations. If they had the power to correct what was happening, or they can also be held liable even if they didn't know about the discriminatory conduct, and even if the person who was acting, like say the maintenance person, was being willful or malicious and had been specifically told not to do the bad things they're doing, the employer can still be held liable. So for those people who are in a position of supervising others, it's really important to train your employees and to make sure that people are aware of these anti-discrimination protections, and make sure that the written policies that you have are consistent with that training, and making sure that all of this is embodying these anti-discrimination principles. So, and then another word, there's been some discussion in the chat about this. I'm going to skip this example in the interest of time, but I'll do one example really quickly. So maintenance man sexually harasses a tenant in the common area of an apartment building, and the landlord has a written policy saying we don't do harassment, and has told this maintenance person do not harass people. Can the landlord still be held liable under FEHA? And you can put your answers in the chat here. So the answer is yes. So this is going to be vicarious liability. The landlord has to supervise. I would guess from this fact pattern that the landlord was aware that there was a problem. Otherwise, why are they giving these specific instructions to the maintenance person? So telling them don't do that bad thing is not enough. So that person could be held liable. Enforcement. So someone in the chat was mentioning, it sounds like I really need a lawyer in order to enforce all of this. And lawyers are helpful with these things, but the idea of these regulations is they are supposed to be accessible to people who don't have legal training. They are written in a way that is easy to read with the examples. And there is a process that people who don't have legal representation can do to enforce their fair housing rights. And that's with the Department of Fair Employment and Housing, DFEH. They have a complaint process that you can do by phone or online to try to address something that's happening that you think is violating FEHA. Or they also enforce other anti-discrimination provisions like anti-hate crimes and several other civil rights laws in California. And then also there's the option of filing a court action against someone who is engaging in discrimination. And as Ugochi mentioned, these laws come up in the defensive posture when a tenant is being evicted from their housing, and they can raise fair housing allegations as a defense to say, I should not be evicted for this reason. I should not be evicted because really my landlord is evicting me because I got arrested. And as we heard from Marie Claire, you are not allowed to treat someone differently based on an arrest alone. Or I have a person with a disability, I asked for a reasonable accommodation, my landlord ignored me and now is evicting me. So this can come up in the defensive posture as well in a court action. And then the fair housing protections are also relevant in a lot of different administrative proceedings that are outside of courts, such as subsidized housing providers often have some kind of grievance process that's sort of an informal process where the tenant will sit down with someone at the housing provider and sort of talk about what happened, how do we solve this problem? And these fair housing protections apply there. They also apply where a developer is seeking to build housing in a community or going through any part of that process, getting permits, getting public approvals and other things. So these fair housing protections apply there as well. So I'm going to stop. I'm hearing that maybe my sound is going out. I apologize for that. And we are getting close on our time. So just flagging here that we have some resources for you on the DFEH website, and the DFEH is continually putting out new educational resources. Okay, Ugochi, turning it over to you to do our call of action, and then we'll take some questions.
Hi there again, everybody. Let's see if it can be seen. Just want to thank everybody for their time, their attention to this very important matter. As we've seen, as we've heard, the COVID-19 crisis, the pandemic, has really shone a light on the housing disparities and further highlighted the need for the enforcement robustly of these fair housing laws that we learned about today. People of color, Black people, people with criminal histories, people who are indigent to this country, and people with disabilities have long been excluded from communities of opportunity, and that has prevented them from obtaining decent, safe, and affordable housing through institutional discriminatory practices. So we hope that you take away from this training the need to use these regulations to make sure that we have housing that's more equitable and just. Thank you again.
Thank you, Ugochi. And I think we're going to take questions now. I see that we have some questions in the question and answer box. So, I think Marie Claire, you want to do this part, but I'm going to answer the first question live, and then maybe my fellow panelists can jump in. Thank you. So the first question is if RENA is not being implemented in a locality, would that be considered discriminatory? And I'm paraphrasing a little bit. So RENA is the Regional Housing Needs Assessment. I think I got that acronym right. But basically, communities are assigned, this is how much more housing you need to meet the need in your community. And it's divided by different income levels. So if a community is not building enough low income or very low income housing, then that would raise fair housing issues. As Scott was talking about, we have a whole set of regulations on land use and perpetuating segregation. For example, if you're living in a community that is mostly high income and is zoned for single family homes where only wealthy people can live, then there's a potential fair housing violation there, because that community is not welcoming in people of lower incomes who are disproportionately likely to be people of color and people with disabilities. So yes, that is a fair housing concern. Let's see. Anyone want to grab a question?
Let me just say one thing to add to Madeline's answer. There was a question about the intersection between affirmatively furthering fair housing and the fair housing regs. And I think this is an example where if a jurisdiction was not enforcing their RENA, that might be an indication that they're not affirmatively furthering fair housing. And even though affirmatively fair housing has been cut back a little bit on the federal level, we do have a state law that covers affirmatively furthering fair housing, and we're expecting some guidance on those provisions soon.
This is Ugochi. I see a question. Would requiring proof of identification to pay rent constitute a FEHA violation? I think it depends. And it depends on what exactly is proof of the identification that the housing provider is seeking. Because if it's information that is being asked of other tenants, then it may not necessarily be. But if it's being asked of specific tenants, particularly those tenants who are receiving some types of subsidy to pay their rent, or receiving assistance to pay their rent, and it's not being asked of other tenants, it might be either evidence of intentional discrimination or discriminatory effect if it's a neutral policy that has the impact of affecting other people who are in a protected classification.
So I can answer one question. I'll read it first. When discrimination occurs, especially when related to criminal records, it seems that the problem is that the screening is just not transparent. So it isn't known by the impacted individual. The applicant doesn't know that their rights are being violated, and or by the time it can be addressed or adjudicated by the state, it's too late to address the impacts. So for example, the housing they applied for is already leased to somebody else. What policy changes are needed to address this? And so, I mean, I'll just say that I think a lot of times, we work with a lot of advocates across the country who are looking at improving the criminal records policies that are in their jurisdictions. And, part of it is trying to reach out to individuals who have been harmed. And then part of it is also making use of fair housing testing that's going on with that is available within your jurisdiction, because what we have found is that in certain places it's almost known where there are properties that are not following the rules, or not that don't have compliance screening policies. And so we often try to work with fair housing testers to determine that, because that also helps you to understand where there might be instances of intentional discrimination. And I think in general, I mean, this isn't necessarily a FEHA specific issue right now, because FEHA really just looks at what the policy is. But I know there have been certain jurisdictions that have included a requirement of having a copy of the screening policy or having a copy of the criminal background check provided to the person during the application process, so that they're more tipped off to the fact that this is factoring in. And one thing that I didn't note in my presentation is that there are jurisdictions in California that have criminal, like what we call fair chance housing ordinances that offer broader protections than the state does. And so in those instances, the local jurisdiction's ordinance would apply. And so in certain places, so like Richmond, California, Berkeley, Oakland, and I think they're in San Francisco. In those jurisdictions, you really have to look at those laws, and those might provide some additional protections that would make the process more transparent for individuals who are going through the application process.
I can answer another question. I'll read the question. Let me pull it back up. It was the question about screening for gang affiliation. I think based on what we learned today in terms of criminal history and regulations, that a screening of that type would be problematic. I can turn it back to Marie Claire, but I think that would be problematic based on the tools that we've learned about using people's alleged criminal history against them when they're seeking to obtain new housing opportunities.
Mm-hmm. I mean, I think you really have to kind of go back and look at the analysis that's laid out. I mean, I think, the FEHA lists some that are specifically off limits. So like the arrests. So looking at that, like how are you determining gang affiliation, I think is probably the central question there. And to the extent that it's using criminal records, I think is a question, but it's still, FEHA in general, like it looks at disparate impact and lays out rules around that. And I think that might be one way to do the analysis to figure out whether screening somebody based on gang affiliation would be violation of FEHA.
I just want to flag that we are a little bit past our time and want to make just one general response to some of the questions. I don't think we're going to be able to get to all of them. I apologize for that. But there have been a few questions about algorithms that housing providers use. And unfortunately, the Trump administration, HUD under the Trump administration, has proposed this rule on disparate impact liability that has very, very ridiculous language about algorithms. I think we're expecting that rule to come out and be final at any time, and it will be challenged by fair housing groups. But the proposal from the federal government is basically like make algorithms into a black box so no one knows what's happening and they can freely discriminate. But here in California, thankfully, we have the Fair Employment and Housing Act, which right now we don't have specific provisions about algorithms, but I think many of the theories that we have talked about here today would apply to the way that an algorithm works. And we also have separately, there's many overlapping consumer protections that require different things, like that when someone is rejected for a criminal record, for example, that they get information about what the criminal record is, the entire thing, so they can say, hey, that's not even me, or respond to it. So there are protections there, but just to sort of let you know that on the federal level, that is not going well. So we are lucky here in California. But I want to respect people's time, and I know that the folks from Housing in California wanted to make some closing remarks. And before we close, just wanted to thank you so much to our awesome panel, and thank you to Housing California for hosting us today. Am I wrong that Housing California wanted to make some? I thought you were going to do that at the beginning, which is why I was just sitting here silently at the beginning. So sorry if I've misunderstood again, but thank you everyone for joining us today.
You can go another couple minutes if you'd like, otherwise we can close out.
I think let's be done. Let's
Thanks,
go stop the
everyone.
addiction cliff. Thank you so much, everybody.
Thanks to our presenters.
Bye.
Thank you.
Thank you.